you know that a woman is suing Disney because she got a wedgie on a water slide? What a positively preposterous idea. SIMBIB. Hello everyone, welcome back to Things I Do Because I'm Bored. My name is Shin, and I am your host. And this fine day I want to speak to you about the ludicrous accusations leveled against one of my favorite companies, Disney. Hey, who the hell are you? I have no idea who that was. Welcome back to Stuff I Make Because I'm Bored. My name is Sin and I will be your host, and today I want to talk to you about so-called frivolous lawsuits. If you've been on the internet as long as I have, you've inevitably come across some article titled, "Woman Sues McDonald's Because Her Coffee Was Hot." And maybe like me you thought, what an absolute dunce this woman was. Obviously the coffee is hot. How could she sue McDonald's over something so obvious? It's stuff like this, I imagine, that leads the rest of the world to think that Americans are trigger-happy, lawsuit-wielding maniacs who will sue you at the drop of a hat over absolutely anything. But is that really the case? Can a woman really sue Mackie D because her coffee was hot? Can someone sue Disney over a wedgie? Let's have a closer look at what's actually going on here. Usual disclaimer, I am not a lawyer, I'm just some guy researching shit online. Part 1. How suing works. How does someone sue a company, and what exactly is a lawsuit? A lawsuit is a legal proceeding in which the plaintiff, the person suing, presents evidence that the defendant, the accused party, caused them harm in some way, such as through breach of contract, negligence, product liability, fraud, or violation of consumer protection laws. A lawsuit is started by the plaintiff filing a claim with the court. This claim contains details of what happened, the evidence to back that up, ideally, and the legal basis that they have to make this claim. This claim is then served to the defendant, who has a set amount of time to reply to this claim with evidence to the contrary. Then both parties present their evidence to each other as well as the court, which is followed by an oral questioning period of both parties by the opposing legal teams, outside of a court. This is done to get a finalized or transcribed version of events from both parties, which would be the basis of a trial. After this questioning period, both parties can agree on a settlement in order to avoid going to an actual trial. But if neither of the parties can agree on settlement terms, this is when the case goes to trial in an actual court. And I'm sure you know what a trial is. Your Honor! Objection! You have been found guilty of murder! When companies are involved, it doesn't usually come to a trial. Not only are trials expensive, they are lengthy, and worst of all, the information is publicly available under the Freedom of Information Act, at least in America. Lawsuits may be available in full or in part, depending on what information is inside. Sensitive information, such as medical records, company structure details, etc., are usually redacted, and some lawsuits may be so sensitive that they're not available at all, but I think those are more like government secrets that are not available. It's not really easy to obtain transcripts for a lawsuit unless it was a public trial. From what I can tell, you need to pay for one for starters, but it is possible. This would make it very important for companies to settle outside of court, because while the claim may still be visible, the settlement terms don't have to be because they were done outside of a court. And because of this, any claim could be made out to be frivolous. After all, there's no proof that the defendant was actually judged to be guilty in a court of law. Part 2. Frivolous lawsuits. Someone could file a lawsuit for any number of real or made-up reasons, but a lawsuit is considered frivolous if there is no legal basis for the claim that was filed. As I mentioned, if someone files a claim, the defendant must respond to the filing. This costs time and energy and money, and if found false, could also be grounds to sue someone back for harassment. Someone could also file a claim for media attention, and a frivolous lawsuit could be filed in order to postpone other lawsuits. Something like, say, a former twice-impeached president suing the Department of Justice in order to postpone a certain other lawsuit. But that's neither here nor there. So what protections are in place to protect defendants against frivolous lawsuits? Well, for starters, a court has the ability to throw out a claim it finds frivolous, right as it's filed. For example, in 1993, a man sued Bud Light after he drank a full six-pack and did not see beautiful women on a beach, as was shown in commercials. The court threw this case out, and that decision was upheld when he filed for an appeal. If someone files a frivolous lawsuit, they can also incur massive fines, essentially for wasting the court's time and therefore taxpayer dollars. And no lawyer would take a case that is obviously false for the same reason. And like I mentioned, the plaintiff can also be sued right back by the defendant for wasting the defendant's time and money because they needed to respond to the original claim. And now that we're armed with this knowledge, let's discuss Part 3, Media Coverage of Lawsuits. Let's look at this recent article titled, "Woman Sues Disney Over Waterslide Wedgie That Left Her Injured." An article from October 3rd, 2023, published by USA Today. And I'm really not going to get too deeply into clickbait headlines in this video, but this is certainly a ridiculous sounding headline. Even my worst wedgies weren't so bad as to sue someone over. And maybe this woman was wearing some stupidly small frilly swimwear or something that got caught in the slide. Honestly, it sounds like it was her own fault if you ask me. This is misogyny, by the way. Let's actually read a bit of this article and decide if this is actually a frivolous case. A couple is suing Walt Disney Parks and Resorts after one of them sustained an injurious wedgie at Typhoon Lagoon Water Park. Emma McGinnis got hurt while riding the what now? Emma McGinnis got hurt while riding the Humunga Cowabunga water slide in October 2019, she and her husband Edward said in the lawsuit filed in Orange County, Florida last week. Note that the injurious is in quotations, because it's an alleged claim at the moment and hasn't been proven in court yet. A little further down in the article, it gives a description of the ride in which it happened, which apparently has a 214-foot near vertical slide. Sorry, I just got vertigo thinking about that. Anyway, a 214-foot nearly vertical slide that drops you off into a pool of standing water at nearly 40 miles per hour. McGinnis got hurt upon hitting the standing water when her one-piece suit was painfully forced between her legs and water was violently forced into her body, allegedly, for which she needed to be hospitalized. She and her husband are presented by an attorney, Alan Wagner. So, based on what we learned before, is this actually a frivolous lawsuit? Well, the claim was filed to a court, and so far it has not been immediately dismissed, so it's not frivolous enough for that. Second of all, the couple has an attorney, so at least one person believes that they have enough of a case to win a suit against Disney for negligence. And finally, the couple's only suing Disney damages exceeding $50,000 exclusive interest and costs, which, based on my limited knowledge of healthcare costs in the US of A, it is fairly reasonable, if not a slightly lowball number for the hospital fees that she would have incurred based on her alleged injuries. All these 3 points combined, I don't think this is a frivolous lawsuit at all. I think this couple has a real case against Disney for negligence. Compare this with another article that I saw recently titled "Pain and Suffering at the Apple Store," published by the New York Post on March 24th, 2012. The article reads as follows. For one 83-year-old grandma, the most confusing piece of technology at the Apple Store wasn't an iPad or an iPhone. It was the front door. Evelyn Paswall, a former Manhattan Fur Company vice president, claims the tech company's signature glass architecture is a menace to little old ladies after she failed to see the glass door at a Long Island location and smashed her face. She fractured her nose walking into a barely marked glass door at the front of the shop, and was one of many people who got injured in this way because Apple didn't put up proper signage warning people that the glass was there. The case ended up getting settled out of court, so unfortunately we have no idea what was actually decided or for what amount. But we do know that Apple did not sue her back for libel or for pushing false claims, which certainly says something to me. And of course, most famously, the story that went viral before viral was a thing, the 1992 case of the woman who, quote, sued McDonald's because her coffee was hot. She suffered incredibly serious third-degree burns to her legs and genitalia because the coffee that they served was 30 to 40 degrees hotter than other restaurants. A third-degree burn goes through every single layer of your skin, by the way. They were horrific. And she won $2.7 million in that lawsuit, but she settled for $800,000 instead, because all she wanted was to get her medical fees covered. And every single article about this lawsuit at the time berated her and treated her like an absolute moron for not understanding that coffee is hot. Part 4, in conclusion, The point of this video is twofold. Number one, media headlines, especially today, are less focused on giving you an accurate snapshot of what the article is about and more about making sure that you click and read the article. Or better yet, spread the article to other people as rage bait. And number two, companies have a vetted interest in making sure that you think the person who sued them is as stupid as possible, and that the company was actually the victim in any situation. A company's only concern is making money hand over fist. So far, Disney has not responded to the water slide incident, but I will say that I was pleasantly surprised by the headlines, all leaning towards neutral rather than patronizing. But it would not surprise me that if they settle this case outside of court, there will be then some kind of rumor or slander that starts to spread about how McGinnis was just a hysterical woman who doesn't understand how water slides work. Much like how any article I found for the Apple Glass case was alleging that Paswell was just a dumb old lady. To McDonald's, serving coffee at a temperature 30 to 40 degrees higher than other restaurants meant that they could make coffee less frequently, saving them costs and ingredients, and the cost that they saved doing this outweighed the occasional complaint they would receive, or the costs of claims that would be filed against them, with absolutely zero regard for the safety of the customers who would be doing the suing because they got hurt. In today's world of rapid media and the public outrage machine, it sometimes feels like media literacy is at an all-time low. It's much easier to read a headline and make a snapshot judgment than it is to do the research needed to actually make a factual-based opinion, especially in the absolute bombardment of news that we receive every single day on social media. But at the end of the day, I do think it's important to do your due diligence for the things that matter. If a headline alleges that a company is being unfairly targeted by some crazy customers, or it makes you angry about a situation that you're not that familiar with, or it tries to alter your perception of a group of people, before getting emotional, ask yourself this question: who profits from presenting you this topic in this specific way? Phew, that was a short but an interesting one. I wanted to cover frivolous lawsuits for a while, so I'm glad I actually did. Honestly, it goes hand in hand with the much more complicated topic of news coverage of these sort of things, but in the end I think I did a pretty good job balancing the information. Did you know about frivolous lawsuits? Have you ever heard about any of the cases that I mentioned today before? And did your perception of these cases change through this video? Let me know in the comments. Thanks for spending some time with me. If you thought it was time well spent, leave a like, subscribe if you'd like to see more videos like this in the future. I post videos every Tuesday at noon Eastern. If you want to hear from me more frequently and if you'd like sneak peeks into future videos, you can follow me on all my social medias. You can find the ats here and in the description. But that's all, folks, and I'll see you in the next video. Bye! Simbib, stuff I make because I'm bored. I've unpacked all of the boxes except for one, and I'm feeling really happy with the setup in my new house. I hope you guys like it too. You can see my figurines much better, which makes me really happy.